speaking from the Vermont Supreme Court. Well, I'm not at the court. I'm at my home office, so to speak. It's a desk and a computer in my living room, and it's worked out uh, actually just fine for the last 15, 18 months or so, where primarily I've been working from here with visitors interspersed. So if you see a dog or two or a baby, our youngest daughter had a baby just about a year ago, and my wife helps out, uh, and he's just starting to walk. So if you see somebody strolling through, don't be surprised, and we'll we'll just keep going that way. I don't know how to fade my screen so you can't see what's in the background, and so that's why it's there. We have four, I think it's four or five perhaps presentations before we take a break this morning. We're going to take a break at about 10:30. 10:35 is what we're shooting for. Of course, that's not a hard and fast rule that we're going to apply. Um, and the presentations, I think, are going to be very good. You've seen some materials already that were passed out before we started this morning. And you should have in your email inboxes already, including the PowerPoint presentation that CSG is going to make. I think after the break is when that's going to come, and we'll look to adjourn by about 12:30. Uh, CSG is once again doing a terrific job, and I can't tell you how impressed I've been working with folks. I don't know if Sarah wants to break the ice on what her uh, expectation is over the next couple of weeks, but I won't say it. But uh, congratulations, Sarah, is all I will say. Um, we've got all of you have available the chat box if you want to make a comment or ask a question. I know all the presenters in the past have been fine with you doing so midstream, so to speak, so we won't carve out specific time at the end of the presentations for that. But if for some reason the chat or raising your hand is not working, just start waving at the computer screen, and we'll recognize you. Okay, this is live streamed. I want to remind you on the Vermont Judiciary's YouTube channel. Um, it's a public public meeting, of course, and as Senator Sears and I were talking before we started, uh, we are on a WebEx platform this morning. Not that it necessarily makes any difference to anybody, but just in case. So I'd like to go around the table, so to speak, and I'm just going to call you out by your first names, if you'd indulge me, and then I'd like you to introduce yourself and who you're with, who you're here on behalf of. But no long comments. We've got about 10 minutes to do this. So, Sam, we'll start with you, Sam.
Thanks, Chief. Hi, folks. My name is Sam Griffith. I'm an operations assistant for the state. I'm helping run the live stream and the WebEx meeting in general. If you are having any WebEx issues, can't hear, can't see, I just dropped my email into the chat. Feel free to send me an email and I will help diagnose. Thanks.
Thank you, Sam. Loretta.
I'm Laura Saki. I'm a policy analyst with the Council of State Governments Justice Center. Happy to be here.
Alice Emmons.
Alice Emmons. I am chair of the House Corrections Institutions Committee and a member of the working group through being a legislator, one of the 4 legislators on the group.
Alice Nitka.
Alice Nitka. I'm a member of the Senate Judiciary Committee.
Ashley,
Good morning, I'm Ashley Messier. I'm the Executive Director of the Women's Justice and Freedom Initiative.
Dale,
Good morning, I'm Dale Crook. I am the Director of Field Services for the Vermont Department of Corrections.
David,
Good morning, David Scher, Assistant Attorney General representing the Attorney General's Office.
Dick, Senator Dick,
Dick Sears, State Senator, Bennington County, Chair, Senate Judiciary, member of the Advisory Board to the Council State Government's Justice Center.
Dr. Aton,
Good morning, Eitan Nasreddin Longo. I am the chair of the Racial Disparities Advisory Panel.
Falco,
Good morning, Falco Schilling, Advocacy Director for the ACLU of Vermont, here on behalf of James Lyle.
Gary,
Good morning, Gary Marvel, Field Operations Manager for the Department of Corrections.
Jenny,
Good morning, I'm Jenny Samuelson. I am the Deputy Secretary here at the Agency of Human Services.
Judge Tom,
Tom Zone, Superior Court Judge. I'm Chair of the Sentencing Commission, and Judge Grierson asked me to attend today in his absence.
Karen, Gannett,
Excuse me. Hi, everyone. I'm Karen Gannett with Crime Research Group.
Karen Tronsgard Scott.
Good morning. I work at the Vermont Network Against Domestic and Sexual Violence, and my role there is as its executive director, and I am a member of the working group. Thank you.
My friend Lisa.
Good morning. Can you hear me?
Yes, thank you, Lisa.
Hi, Mr. Ryber. Lisa Ryan, Director of Domestic Violence Response Systems at the Vermont Network Against Domestic and Sexual Violence. Happy to be here.
Madeline.
Good morning, Madeline Dardo. I'm a Senior Policy Analyst at the Council State Government's Justice Center.
Mary Jane.
Good morning, Mary Jane Ainsworth. I'm the Director of the Parole Board.
Matthew.
Matt Valerio, Vermont Defender General. Good morning.
Patricia. Pat Gable.
Good morning. I'm Patricia Gable, State Court Administrator.
Regina.
Good morning. I'm Regina Herder. I'm a technical assistance person through CSG to the project that they've been working on through JRI.
Maxine.
Good morning. I'm Representative Maxine Grad. I chair the House Judiciary Committee, and I'm also on the working group.
Sarah Bostomsky.
My name is Sarah Bostomsky, and I'm a research manager with the Council of State Government Justice Center.
Sarah Friedman.
Good morning, everyone. Sarah Friedman, Deputy Program Director with the CSG Justice Center. Great to be here today.
Susanna.
Hi, buenos días. Susana Díaz, Racial Equity Director for the state.
Okay, thank you, everybody. Who did I miss? Would you speak up, please, if I missed you? Looks like we got everybody. Yes. Jim Baker. I don't think I got you. Jim.
Good morning, Judge.
Good morning. Who else? We miss anybody else? If you didn't have a chance to identify yourself, please speak up.
Good morning, Chief Todd Delos, AHS General Counsel.
Thank you, Todd. Anyone else? Okay. All right. Any questions about process or procedure that we're going to follow? As I outlined a few minutes ago. If not, I'm going to turn to Madeline Dardo. Madeline?
Great. Thank you, Chief. So this morning, folks, we wanted to start off by having you all hear from representatives from the agencies and departments that have really been putting in a lot of the day-to-day work to implement the reforms of Act 148, as well as your additional January 2021 recommendations. So as you all are the oversight body for Justice Reinvestment 2 implementation, we just wanted to make sure that they have the opportunity to share their progress and really the tremendous efforts that their staff have made over the last several months to develop and implement some significant system changes. And so to start us off this morning, you'll be hearing for representatives from the Agency of Human Services, Department of Corrections, and the Parole Board. And so with that, I believe I'll actually just turn it over to Deputy Secretary Samuelson, who's going to provide you all with an update on the working group's January recommendation related to care coordination and information sharing. Deputy Secretary?
Good morning. It's exciting to be here this morning.
Good morning.
The Agency of Human Services has really been committed to justice reinvestment, and we've been working closely over the last couple of weeks with the last couple of months with the Council of State Government to pull together all of the departments across the Agency of Human Services. We're committed and believe that it will require an investment of each of our departments in different ways to be successful in this overall project in terms of enhancing care coordination. And we believe that there's significant synergy in the broader agency goals and the goals of health care reform along with justice reinvestment. For the last several months, we have had the commissioner level support coming from each of the departments to really hone in on a project that we believe we can bring from pilot to program relatively quickly. We have committed to bringing together our Vermont Chronic Care Initiative program, which is looking at, let me take a step back. We have committed to taking and bringing together the community resources around the individuals who are in our corrections system at both those who are incarcerated and those who are currently in our probation and parole offices. Over the next couple of months, we are bringing together our chronic care initiative, who will be working within the context of our probation and parole offices to screen individuals for the level of care that is required and necessary, including really looking at their social determinants of health, their issues related to mental health, substance abuse, interpartner violence, housing insecurity, and food insecurity, to identify their needs and to pull in the community resources that are necessary. Through that process, our Vermont Chronic Care Initiative is embedding themselves in our probation and parole offices. Initially, they will be our chronic care initiative is embedding themselves in those probation and parole offices to do that screening. They've also engaged our healthcare providers through their overall model, including in the pilot in Burlington area, where they're pulling in the federally qualified health centers, the Community Health Center of Burlington, and engaging them in providing the wraparound care and services. I'm gonna, sorry, I've lost my place and lost my spot there. So far, they have worked through a workflow and process where they're pulling data from the probation and parole offices, identifying those clients who are high need and high resource, and have yeah. Tim, do you want to pitch here for a second? They've identified those are high. So far, they've identified 4 individuals. Of those 4 individuals, they've been able to provide wraparound services and screen 2 of them. We believe that the model of care that they're providing will help to engage. Will first help to engage a connection with identifying the model of care, a connection with our healthcare system, and determining the mechanism for incorporated payment models as we move forward. We're confident that as we go forward, that we will be able to engage the designated agencies in our model of care, that we will be able to engage our primary care in our model of care, and our ADAP system in our model of care. I'm going to pause there.
Okay.
I apologize. I'm going to go ahead and take any questions with that so far.
Thanks, Jenny. Any questions? Anybody have any questions or comments? You can pose a question to yourself, Deputy Commissioner, if you like. All right, I guess not.
And I know the Department of Corrections is our next update, Chief, and so they've also been really involved in this AHS project. So I don't know if it makes sense to transition to their update, and maybe they can also add to anything that the Deputy Secretary might have said.
Yes, hi, Dale Crook, Department of Corrections. To kind of follow up from Deputy Secretary Samuelson, this pilot project we have going on in Burlington was kind of at the direction of Commissioner Baker, and really kind of gave us the opportunity to explore a different way of looking at how we do our business, really to focus more on supporting supervised individuals as opposed to really supervising them, with a mindset that we still have a public safety mission. It's really given us the opportunity to be very creative in how we work with a very difficult population, not necessarily a high risk or high danger type population, but really the population that is drawing a high percentage of resources from the department and the agency. We're being creative by using other types of technology, motivational apps that will help track individuals' motivation to change. We're looking at intervention models that will best address the needs of the supervised individual, as opposed to the more traditional ways of supervision. And it's still somewhat in its infancy, and it's kind of a working model. We're really looking at how we can best address this very complicated population, keep them in the community safe and stable, and working them to transition them to be productive citizens in our community. So far, I think things are going fairly well with it. It's still small. We're still trying to work out some kinks. We do have referral mechanisms. VCCI has been a great partner with us, and they're coming to our office. We're connecting people with the services that they need that are kind of outside of the department. It's still a work in progress, but I think so far things are going fairly straightforward. We do have steps ahead of us around funding mechanisms, how we're going to look to fund some of the programs that we need to have done. But I think that's all within reachable and achievable goals that we can accomplish. Any other questions about the Burlington pilot project? And then I can move on to the additional implementation updates for JRI from the department. I'll take silence as permission to move on. Act 148, the department has implemented that. It's in place and it's operational. There's really has been surprisingly few significant issues with that rollout. It was a different way of doing business for us and our partners. We still meet weekly. We've had great partners with our implementing this. The parole board, ED Ainsworth has been great in working with us to really help with the parole side. We kind of vamped how community supervision is done. We have looked at our return processes. We've had reduced them dramatically, the number of individuals going in for technical violations. So the Act 148 seems to be moving pretty well. And right now there's really no issues or red flags to report on that. So that's been a good implementation start off with. So we do have a sub-award that has been granted with the help of JRI, or CSG, I should say. And with that, it's really 5 training contracts are kind of slapped together for this. The first training is going to be with the Alliance of Community and Justice Innovation, which is really sit as an AHS-wide training that's going to support the organization and implement new ways of kind of doing business as a greater agency with our population. So that's been working on. The secretary is the lead on those trainings, and that is in process right now. Another grant is with the Advocates for Human Potential. This really focuses on our transitional housing partners and best practice in working with justice-involved individuals. As everyone knows, the department really took a hard look at how we have funded and utilized transitional housing in the past, and based on recommendations, we have revamped and awarded new contracts. And this training is to help kind of bridge the gaps between the transitional housing partners and our staff, and how to really leverage the work that we both do for the best benefit of our supervised population. We also have another grant through the Justice System Partners, which is going to focus on the use of our risk assessments, and working with the parole board and DLC staff on how, what is the risk assessment, how should we use it, how to case plan and supervise based on the risk assessments. And that is lined up as well. The fourth is through Alternative Solutions for Associates. And this is going to be focusing on the intersection between criminal justice and behavioral health clients. It's really going to focus around communications and collaborations. This is to allow, the designated agencies and other community partners that the department and our populations deal with on how to best share information, how to best work with each other to best implement strategies to help address the population that we're supervising. And our final one is through the University of Cincinnati. It's to revamp the contracts and focus on updated training for EPICS. And EPICS is a communication process. It's called Effective Practice in Community Supervision. It's under the UCCI. It's an evidence-based intervention model that the department currently uses, and through some of this sub-award funding, we're going to increase our training staff, and we're going to increase the implementation of that throughout the department. Another benefit of the sub-award is really going to be going to upgrade our Department of Corrections, our offender management system. Right now, we are working with the Agency of Digital Services on the approval process for these contracts. The project scoping is currently underway, and we've been working on that for months now, knowing that this funding is coming. And really the modules and the upgrades to the offender management is to support implementation, make it more user-friendly for our staff implementing data into the system, as well as improve data collection and report out. So that's really one of the emphasis from the CSG recommendation, is about data and be able to track data and use data for changes in policy and practices. And that's moving along, just waiting on the process to get approved. Act 14, which is a felony probation condition pilot. The department, the state's attorneys and sheriff's association, the Defender General, the judiciary, and the Attorney General's office have probably met 3 or 4 times now. And we have a pilot site that is located out of Bennington County, will be the initial pilot site. The plan is to hopefully start the implementation. We have a meeting set up in September to launch it and finalize process steps and set up what we need to do as far as data collections and evidence for the evaluation. with the hope that after we kind of get the kinks worked out of Bennington County to open it up to another site in order to see how transferable it is and see how it will work in a secondary site. There's going to be a lot of cooperation right now because it is going to kind of work with the sentencing and the court process on how we implement these risk assessments to better match probation conditions for the probation population to hopefully get better outcomes and to reduce the intensity of supervision that's not necessary and really focus energies on where we'll get the best outcomes for their population. In addition, Act 24, which is the term probation midpoint review, the department has updated its policies and practices as of July 1st of this year. That currently moving on, there are some kind of growing pains with this. This is, I think, a little bit more of a workload issue than it was anticipated, not so much by the department, but by the criminal justice system as a whole. So we're working through that. The State's Attorneys and Sheriff's Association, we've been working with on how to better provide information to the state's attorneys. There have been a couple of concerns that were brought up around the workload. The department, as I don't know if people understand, but Act 24, the department has very little discretion on who we submit motions for discharge and review for. And we're trying to find ways to make it more practical. For example, the department will under the law, we'll be recommending discharges for people pending violations of probation or new charges. And that's just part of the process because there's no discretion. We're working with the courts and the State's Attorneys and Sheriff's Association on how we can more effectively handle those types of cases without having a huge drain on the court system, which is already taxed based on the pandemic that we're dealing with. They've been good partners with the department, and I think we are working, as issues come up, we're working together to resolve those issues. And that is moving forward right now. Those are the updates for the department. I'll be more than happy to answer any questions, or if Commissioner Baker has any additions that he would like to add. Not to put the commissioner on the spot. Yes.
I have a couple of questions, Chief.
Yes, please.
Dale, you give us, not now, but copies of your plan for additional housing and how it ensures that there will be adequate housing around the state, not just in certain geographic areas. And that was, so if you could provide us with that, it'd be helpful between now and the next meeting. Also, I'd heard that the number of community correctional officers in the community is also down. I know you're having trouble staffing the correctional facilities, but is that a fact? And if so, how are we making sure that offenders are held accountable in the community?
So that is correct, that we are about half staffing where they're community corrections officers. Really their focus right now is to support the facilities as much as possible. We still have probation and parole officers. We have not stopped hiring or recruiting them. They are still intervening and addressing issues and behaviors. We're still holding offenders accountable. We are trying to manage the best we can, but we are down staffed a little bit, as I think a majority of departments are. It's a difficult hiring situation right now across state government and across the state. So we are working with that. We're trying to balance the resources that the department has to the best outcome for the state of Vermont. And I don't know if the commissioner would like to add.
Yeah.
Go ahead, Senator. Sorry.
No, I just want to ensure that this is something that the participants at this meeting and as well as the Justice Oversight Committee is aware of. I've been made aware that it is a problem in the community that where we had a number of community correction officers in the communities that they are now staffing in facilities, et cetera. So I just am concerned about all the things we're trying to do in the community to keep people in the community and then losing the ability to hold them accountable.
Yes, Senator, I'll add to what Dale talked about. We've held off on advertising those positions because we know that a good majority of the CCOs will come out of the facilities, making our staffing issue even worse inside the facilities. That's number one. Number two, we are, and Dale touched on this, and Deputy Secretary Samuelson touched on it as well. The training that Dale just covered, some of that training is going to focus on this mindset cultural shift of moving from the term of supervising people in the community to being supportive of people in the community. It doesn't mean that we're not going to hold people accountable, but refocusing the CCOs on a much more holistic approach to the way we manage that population in the community in order for us to keep our obligation on public safety, meet the goals of justice reinvestment too, by not returning people to facilities. So it's a combination of a couple issues. And until we get the current CCOs trained up and we can stabilize the facilities, we're gonna have to live with what we've got right now in order to be able to manage the overall system. If that makes sense to you, sir.
I guess it makes sense, but I want to just express my deep concern for all that we're asking of the communities to deal with. And, you know, I understand you're doing the best you can with what you've got. And I just wanted to share that concern that probation officers' roles then change, trying to cover for the COs in the community. And it all just, you know, it exasperates a difficult position. So I just want to make folks here aware of this, and perhaps at the next Justice Oversight Committee meeting, we could take a closer look at this. But it could endanger what we're all trying to do here and all of your goals and creating pilot projects, et cetera.
No, I agree 100% with you, Senator. And, you know, the last thing I'll say is that this fits into the bigger conversation about the lack of the ability to recruit in the justice system right now. It's a major challenge. Quite honestly, we're doing better than a lot of folks are in the justice system, getting folks recruited, but it's the retention issue. So until we can stabilize that, the residual effect of that is what we're talking about right here.
Thank you.
You're welcome, sir.
There's a question here from Dr. Aton. Will your data systems speak with others in the criminal justice system? Dr. Aton, you want to expand on that?
Sure. The RDAP was tasked by both Act 148 and most recently by Act 65 to look at creating what is tentatively called a Bureau of Racial Justice Statistics. One of the important points of this bureau will be to essentially hire a data architect who will make it so that the various systems that work in the criminal justice system and juvenile justice systems, for that matter, can speak with one another so we can get a sense of data with the ultimate goal of ameliorating racial disparities in both systems. So I was curious when you raised the issue of data systems, whether or not that integration or there are indeed ability for integration was part of your thinking.
I do not have an answer on that. I am not an IT individual. And unfortunately, Monica Weber, who is, I'm sorry, there's an echo, who is our administrative director, would be better to answer that. And I can ask her when she returns from vacation is to touch base with you, Doctor, about what the system as far as IT systems talking with each other, what the plan is for that. I do know we are working on capturing a greater amount of data to work with the goals of the of RDAP. I do know that, but as far as one system talking to the other, I can't give you an answer on that.
That's fine, sir. And don't trouble Monica. She's on the panel. I thought maybe you had some other information that I couldn't get from her. Thank you, though.
Nope.
Okay, thanks. Thanks for the question. Any other, how about other folks? Questions or comments? Okay. Madeline?
Sure. And so I think up next is the parole board. Mary Jane, I don't know that we had a conversation about whether or not you're going to be able to share your slides, your presentation, or if you'd like me to do that.
I don't know if we need to share it unless folks want to see it again. I was just going to go over it. I just wanted to show the data beforehand, but it's up to the group if you'd like it to be shared at the same time. I don't think I have the ability if.
No problem. I'll just go ahead and pull it up so that folks can see it. That should not take too long. If you want to go ahead and get started though, that way I'm not delaying us.
Good morning. I went through the major initiatives that the Parole Board has been working on through the Justice Reinvestment Initiative. The first one I touched on was presumptive parole. As we all know, this was a major change with a slow rollout, being a presumptive. The first presumptive parole legislation only targets non-listed offenders. To roll this out slowly, so the Department of Corrections and the Parole Board could get used to the process and start integrating it. As of the end of July, we have had a total of 10 individuals who have been brought forth for presumptive parole. 7 of those were granted through that process, through the administrative review, and 3 of those were denied in a hearing. An initial eligibility hearing was scheduled for those folks. So then we looked at, so I provided a little bit of data just to show the risk level of the folks that are coming before us for presumptive parole. The folks that were granted are in blue. So the majority of the folks we are seeing fall in the moderate or high category listed in the ORAS. We have been tracking data using the ORAS versus our own risk assessment tool. And then for our presumptive parole cases, we have scheduled, out of the 3 hearings that we scheduled, 2 of them have been approved. And then the third one was actually denied in July, so it was scheduled in August. And I didn't include that data, but we have held that hearing and that person was denied at the hearing due to significant victim issues and the nature of their case. So that is really how presumptive parole has rolled out thus far. Any questions regarding presumptive parole before we move on? Okay. So the next slide that I provided was just a visual of our parole grant rate since 2012, just to see how it's varied over the years. But as you can see, since 2018, 17 and 18, we hit another dip. We have been rising gradually, and then 2020, when we implemented the Justice Reinvestment Initiative, you can see that our grant rate increased by about 5%, and it's stayed there so far this year. Just with the Parole Board looking at things differently, they're more of an initiative to with the community supervision, making it similar for parolees and furloughees. It's just there's more of the goal to place folks on parole versus on furlough. So any questions on our grant rate? Okay, so our next change that we are implementing this fall is risk assessment changes. We have been working with the Council of State Governments, talking through our risk assessment, and we have determined, based on the age of our assessment and that it needs to be revalidated, that we will be discontinuing our own risk assessment this fall. We will be transitioning from this tool to rely on DOC's validated risk assessment, the ORAS, the Ohio Risk Assessment System, to help integrate risk into our decision making. Through the subaward funding, we will be provided with 2 trainings this fall by Dr. Brian Lovins, principal from the Justice System Partners. Director Crook had mentioned some of this training during his presentation. Our trainings are going to focus on how the tools were built to inform the parole board members, how the tools work, and some foundational work. We will also receive some understanding on how the composite risk level interacts with the domain levels, where the ORAS compared to our risk assessment focuses on different domains, where ours is more just general risk, and for the board, how to prioritize this information in their decision making when setting conditions. Any questions on this change? Okay, and then we have the parole board has been accepted into NIC's structured decision making framework, technical assistance program. We will be starting this very soon. This framework is based on evidence-based practice to aid boards with decision making. There are 5 phases to the program. It's about a 4 to 6 months time period to roll out the entire program. The first phase will be starting on August 24th and 25th, sorry, where we will be doing a site visit with Connecticut, where we can view their tool, receive some history of how they implemented structured decision making. We will be able to observe their hearings, speak with their parole board members, and then decide further if this is something that fits Vermont. Myself and Chairman George, believe this would be a great asset to Vermont and our decision making as a whole, because it focuses on specific domains of risk and evidence. And then lastly, I wanted to just touch on earned time legislation quickly. This has been affecting the parole board with some aspects, as we've been finding individuals are waiving their appearance before the board for their initial eligibility hearing, or refusing to see the board when either recommended or asked by the board at their annual review to have a hearing, because they'd like to continue receiving the 7 days of earned time. We are most commonly finding this with individuals who are out in the community being supervised on community supervision furlough versus those that are incarcerated. Currently, we're exploring revising our current early discharge of parole supervision policy to make it feel more attainable to individuals. And also, we're creating a plan to educate DOC staff members, incarcerated individuals, and individuals supervised in the community on our policy. We're finding a lot of individuals do not know that the parole board has an early discharge policy, or they don't know the details of it. So this is something that we are starting to explore. And then in the presentation, I included our policy, our early discharge policy. Basically, the quick synopsis is that If you are a non-listed offender, you must be on parole supervision for more than 3 years without incident or within 6 months of your expiration date. And for listed offenders, you must have been on parole supervision without incident for more than 8 years or within 6 months of your expiration date. And that is our update from the parole board.
Thank you, Mary Jane.
Mhm.
Any questions before we move on? Any comments? So I think, Madeline, we're back to you.
Great, thank you. And I'm going to share my screen again. Just one moment. All right, and we should be good to go. Do you all see that in presenter
Yep.
view by any chance?
Yep. State House.
All right, wonderful. All right, so I'm going to go through these first introductory slides quickly so we can get to some of the data monitoring slides that we showed you last time, but with some additional updates. So for those of you, do you all see this in presenter full screen?
Yeah, Madeline, I changed the
Okay.
view.
Oh,
So
no, actually, Madeline, at least for me, we're seeing your entire window, not the
There,
slide.
that's-
There you go.
There we go.
Now you're on
Okay.
a slideshow. Yeah.
Oh, I just got it. Okay. Sorry, folks. I'm going to not mess with that. All right. So just really quickly, for those of you who don't know, we are the Council of State Governments Justice Center, a national nonprofit, nonpartisan organization that works with all 3 branches of government. And we're in Vermont in support of the Justice Reinvestment Initiative funded through the Bureau of Justice Assistance and the Pew Charitable Trusts. And so just to do a quick recap, this feels a little out of place, I apologize. But just to start us off, we wanted to remind the working group that in June, you all prioritized the following tasks to take for the next 4 meetings through the end of the year. The first is just continuing your ongoing oversight of the Justice Reinvestment Initiative implementation. The second is to continue discussions around the Justice Center's additional analysis on racial equity and sentencing. The third is what we're going to do a little bit later today, which is begin a discussion around policy of parole eligibility for older adults, and then also develop reinvestment funding recommendations for the upcoming budget cycle. And our presentation today will be in 2 parts. So before the break, to kind of go along with the implementation updates you just heard, we're going to provide you some data monitoring updates that we received from the Department of Corrections. And then after the break, we'll go into an update and some discussion around the racial equity and sentencing analysis, parole for older adults, and then finally in closing, just some thoughts on sustainability as well as next steps as you all look towards your October meeting. And so to start with data monitoring, you'll notice this is a very similar slide to what we showed you in June, which is your snapshot, the population trends for your sentenced incarcerated population. And so if you look at that, and I don't know if you can see my cursor, but if you look along that dotted light blue line, that's your population projection status quo. So not taking into account any changes from justice reinvestment or from COVID. And below that in the orange, this is your population projection taking into account the projected bed savings from your justice reinvestment reforms. This is the population projection that our phase 1 team did initially as you all were discussing the preparations for Act 148. And then if you look at the solid blue line, this is going to be your actual prison population, sentenced incarcerated, population as of the end of June. And you'll see that's 911 people. And so this is going to be about 22 people more than what we last showed you in June, which was the population as of the end of April 2021. So when you look at this slide, what you see is that these obviously there was a significant decrease in the sentenced incarceration population due to COVID, and now we're starting to see that just slightly rise. And so then the next the next slide is very similar, but it's for your community supervision population. Again, looking at that dotted line, that's going to be your status quo population projection for the community supervision population. And then in the solid blue line, that's going to be your actual community supervision population at the end of June. It's 5,061. And so, and this is going to be about 262 people less than at the end of March 2021, which was the last data that we showed you at your June meeting. So, unlike the sentenced incarcerated population, Vermont's community supervision population has continued to decline. I guess I can't say post-COVID, during COVID. And you'll notice that we don't have population projections based on justice reinvestment outcomes in this slide because, based on the reforms that you all enacted in Act 148, those were not projections that were done by our teams, our phase 1 team. So we won't have those. And so this last slide is really just a reminder that there are additional measures that are going to be available in future data monitoring reports that are going to help you all really understand these population trends over time. And this includes new prison admissions, including returns from furlough, probation, and parole, new community supervision cases, furlough interrupts, and final releases. And we're bringing this up to you all because it's really, we had a discussion last time about how difficult it's going to be for you all to basically parse out the impacts of your Justice Reinvestment 2 reforms due to the interruptions and trend data from COVID. And so, what we're hoping is that this additional information that we know that the Department of Corrections is working hard to be able to provide is we'll be able to provide some just additional context that's specific to the reforms that you all enacted in Act 148. So to give you an example, during phase 1, one of the primary drivers of Vermont's prison population was identified to be returns to incarceration. So having the return and furlough interrupt information here will help you all have a little bit of a better context to be able to evaluate how the reforms that you enacted are working and what their impacts might be on that kind of broader trend line in your sentenced incarcerated population, knowing that there's also going to be just a lot of anomalies in that sentenced incarcerated data right now due to COVID. And so this is information that, like I said, we know the Department of Corrections is working to provide and that we should be able to have for you all shortly. And I will stop there in case folks have any questions.
Hi, this is Falco from the ACLU. One question I have about the data is, do you think that it will be possible in that information that is going to be coming to not only parse out the justice reinvestment impacts, but also look at other impacts that were implemented throughout the pandemic and how those initiatives might have played an impact in reducing the prison population? Just looking at those reductions are pretty impressive and outpaced what we thought we might be able to do with the Justice Reinvestment 2 initiative. So I guess that's one of the questions, and one of the big questions coming out of this pandemic, or as we go through this pandemic, is what practices were put in place that were able to help us get those reductions, what can be kept in place, and how is that different or can be parsed from Justice Reinvestment 2?
Sure, thanks, Falco. And honestly, that's kind of the $1 million question, right? And it's a question that a lot of jurisdictions are wrestling with right now. I think we mentioned before that we actually have a whole team at the Justice Center that's working with states to try to look at, okay, we saw these reductions in populations due to COVID. Can we safely maintain our population levels, and learn from some of the things that we implemented during the pandemic? And so, like I said, in specifically in Vermont, it's going to be really tough, and I think it's going to be important to be very frank about what the data tells you and what it doesn't tell you. But it's going to be tough to continue to kind of parse out what those, what's specifically related to what. But continuing to have these conversations that you all kind of coming together and talking about what you're seeing in different parts of your system, the additional data, you all saying, okay, well, where does this tell us we want to look? Do we want to dig further here, here, here? I mean, that's going to be what, the really important ongoing conversation to hopefully get you a little bit closer to some of those answers. So not wholly satisfying, but again, knowing you all are not alone in wrestling with some of these questions.
As a quick follow-up, would you be able to compare with other states that are similar to Vermont, like Rhode Island and Connecticut with a unified system? And what numbers they're seeing?
Thank you, Senator. I think that's something we can look into. Like I said, we've got teams that are kind of looking at these things across across the country. And so I'm not 100% sure offhand what we might be able to come up with. I think that's something that we can look into for you.
Muted. Thank you.
Any other questions or comments? Well, Madeline, should we take our break now?
Sounds good to me.
Okay, so
I'll get my coffee.
we'll take 15 minutes, come back at 10:45, please. Thanks.
Be on him. I'm on my phone.
Okay, we're gonna get started. Hope everybody has had a chance to get back. Thanks very much. Madeline, are you introducing the next section? I'm not sure.
Sure. Hopefully you all can see my screen, and I'm actually going to go ahead and turn it over to my colleague Sarah Bostomsky to talk about strategies to reduce racial disparities.
Great. Thank you, Madeline. Folks can hear me? Is
Yes.
that right? Yes.
Yep.
Okay. Thanks for confirming. So as you know, our team is currently conducting racial equity analysis. We're looking at the Vermont criminal justice system, both the courts and then corrections data. We are currently waiting for some final pieces of data for that analysis, and we'll present the main findings this fall when we meet. So today we thought we would take the opportunity to review key findings from the national research literature and discuss lessons learned from that broader literature that could be helpful as we're thinking through, these types of questions in Vermont. Before I dive into the slides on the national research, I wanted to share an important point of clarification, just to reiterate, because we did discuss this briefly in June. Our racial equity analysis will focus specifically on Black-white disparities in Vermont's criminal justice system. And we've also focused this review of the national research literature on that specific subtopic. So the decision to do this reflects both the racial composition of Vermont's justice-involved population, and it also reflects data limitations. So in particular, Vermont courts haven't historically had access to a full range of racial and ethnic data. So we're focusing our analysis on the data that is currently available to us. And I'm happy to speak, more on that if folks have questions sort of during the discussion portion of today's talk. So to give you just a really brief overview of what our slides will go through, first I'll present a very high-level overview of what we know, some key lessons learned from the national literature on racial disparities. And then I will also go over policy solutions that have been shown to reduce racial disparities in other states. And then Sarah Friedman will be going through both some research-informed and common sense policy solutions to address racial disparities. Next slide, please. So this slide may look familiar to folks. We presented it in June, but this is a snapshot of some of the racial disparities that we see across the U.S. So the big picture story here is that racial disparities have improved in incarceration since 2000, but they remain a persistent feature across the U.S. This is true for Black-white disparities in both state prisons as well as federal prison. Next slide. Thanks, Madeline. One area where disparities are particularly pronounced in the U.S. is for drug offenses. So those disparities in incarceration are mirrored when we examine arrest statistics. We know that rates of drug use and sales are similar for Black and white folks. However, Black people are arrested about 3 to 4 times more frequently than their white counterparts for those types of offenses. And then when we look at the incarceration data for state prison, we see that Black people are up to 9 times more likely to be incarcerated across the U.S. relative to their white counterparts. Next slide, please. So evidence suggests that there are a number of factors that contribute to these disparities, right, and drive them. So first, we know that sentencing policy is very important, right? So things like mandatory minimum sentences or 3 strikes laws have disparately impacted Black defendants and populations. We also know that there is evidence that race influences sentencing outcomes even after we account for key factors like offense severity or defendant criminal history. There's still this persistent racially driven disadvantage for Black defendants. And then finally, we know that Black-white disparities in incarceration aren't occurring in a vacuum, right? So there is this accumulation across the criminal justice system of differential treatment and multiple decision points that can drive some of those disparities at the end of the system in incarceration. Next slide, please. So in terms of how these lessons can be applied in Vermont, we do know from the phase 1 analysis that Black-white disparities for drug offenses do exist in Vermont. So this fall, the analysis that we're currently working on and that we're waiting for that last bit of data for, will go into some of these statistics in much more detail and look at drivers, et cetera. But this slide is probably familiar to some folks, again, from the phase 1 analysis. And what it shows is that relative to the total sentenced population, incarcerated population in Vermont, we see that Black folks are more likely to be incarcerated for drug offenses. And this is true for both Black Vermont residents as well as non-residents. So this suggests that what we're seeing in these national trends is also true in Vermont. Next slide, please. Thanks, Madeline. In terms of identifying solutions that can address racial disparities, there are a number of policy options that we've seen from the national research literature that have been shown to be effective. So first, we know that sentencing guidelines or guidance is considered a best practice to increase uniformity and proportionality of sentences. At the same time, we know that guidelines or guidance has been shown to reduce racial and ethnic disparities in sentencing. Presumptive guidelines, meaning judges are expected to follow the guidelines unless there's a specific reason not to, have been shown to be more impactful than voluntary guidelines. And Sarah Friedman will talk a little bit more in depth about how this could fit with sort of policy options in Vermont. Next slide, please. Sorry, one back. Okay, so along, there's actually just, yep, that's it. Thanks. So along these same lines, there are several key lessons learned from states that are interested in improving sentencing practices to reduce racial disparities. We know that a legislative approach is particularly effective, basically to ensure that guidelines are adhered to. Sentencing reform that focuses on increasing uniformity in judicial decision-making can be a tool to improve consistency, not only in judicial decision-making, but also prosecutorial decision-making by adjusting the expected sentence for offenses or the going rate. And then finally, one particularly important lesson learned from this literature is that guidelines or guidance do not need to explicitly focus on racial disparities to reduce them, right? So adjustments that kind of improve uniformity across the system can still have this added benefit of reducing racial disparities. Could you go to the next slide? Thank you. So this slide and the next one show examples of how sentencing guidance has worked successfully in Vermont. So these results may look familiar. They're also from CSG's phase 1 analysis. So specifically here, what we're showing is that Vermont has statutory guidance on probation term length. And this guidance appears to ensure that there are no observable racial differences for average misdemeanor probation term lengths. This is also true for felony probation term lengths, which is what the next slide looks at as well. So this suggests that this type of guidance does work in Vermont. So the next slide shows very similar results of analysis, again, just focused on felony probation term lengths instead of misdemeanor. Next slide, please. So in addition to sentencing guidelines or guidance, another sentencing reform option that can address racial disparities for drug offenses is the reclassification of drug laws. A number of states have reclassified drug possession from a felony to a misdemeanor in recent years. And part of this set of reforms has included provisions that bar people convicted of simple drug possession from prison sentences. And I'm not going to go into detail about all of these different adjustments, but there are a lot of specifics. So for example, in California, the law that was passed does exclude people who have been convicted of serious or violent offenses from kind of receiving that benefit of that reclassification to a misdemeanor. So there are a lot of details there that are important as well. Could you go to the next slide, please? In Connecticut and Oklahoma, policy changes have reduced possession to a misdemeanor offense. So Connecticut reduced the penalty of possession of drugs from a felony that historically had a 7-year maximum sentence to a misdemeanor that had a much shorter incarceration sentence available. In Oklahoma, there was a ballot initiative that was passed which reclassified simple drug possession and made that a misdemeanor and removed the possibility of prison time. And this is for people whose most serious offense was having controlled substance or drug offense. Next slide, please. California and Oregon have passed similar reforms, and this is really where the evidence is strongest that these types of reclassification reforms can successfully reduce racial disparity. In California, this is where the evidence is strongest just because there are the most robust studies available. Proposition 47 implemented changes to both drug offenses and property crime offenses, basically a group of non-serious, non-violent crimes. And what we've seen from the literature here is that this change has been associated with a reduction to racial disparity at multiple indicators across the criminal justice system. So it's had really a robust effect at reducing racial disparities. The indicators that have been studied are arrests, jail bookings, and incarceration. Oregon similarly passed a law reclassifying drug possession, again, from a felony to a misdemeanor. And a recent study also showed that there's a reduction to racial and ethnic disparities in felony convictions in particular. So I'm going to pass it to Sarah Friedman next, who's going to discuss some of these policy initiatives in a little more detail. But I'm happy to answer questions throughout the discussion if folks have them.
Thank you, Sarah. Any
Hi, everyone.
questions? I'm sorry, Sarah. Go ahead, please.
Oh,
No, happy to pause for questions here.
I don't see any. No hands.
Great.
Please
Uh,
go ahead.
Thanks. So I'll take the next part of the slide deck, and I really hope we'll have kind of a robust discussion from here. I just want to note that I live in an apartment building, and there's currently renovations going on downstairs. So please, my apologies if you all might hear some drilling or background noise as I'm speaking. Hopefully it won't be disruptive. And if it is, I will quickly go on mute and pass it off to teammates. But luckily right now it seems like I have a little bit of a reprieve and there's no construction noise for right now. So the purpose of this part of our presentation and slide deck is actually that we're really hoping to brainstorm with you all as JR2 working group members and other folks who are interested in attending these meetings about what policy changes might be feasible for Vermont moving forward to address racial disparities at sentencing if we find them in our racial equity analysis that will be released this fall. And which, of course, as we've seen with the phase 1 slides that Sarah presented just a minute ago, and then in our preliminary analyses, it's highly likely that we're going to be showing you pinpointing some racial disparities in Vermont in sentencing when we release our results. So we're really hoping to just kind of shop around some policy ideas based on what Sarah B. just presented and other policy levers that have historically led to racial disparities in the criminal justice system. So this first slide here is really a direct line from what Sarah B. just covered and where we have the best national research on reducing racial disparities. The next 2 slides, which have 3 additional policy changes on them, are kind of where there's emerging research and policy ideas nationally. And I want to note that, so we're going to be talking about 5 very broad policy ideas right now over these 3 slides, but this is not an exhaustive list by any means. We have more ideas that are kind of percolating within the CSG team that we might bring up as the conversation progresses. And then we're also just very curious to hear from you folks as Vermont experts on other policy levers that we could look at as we're looking at the results of our analysis and helping you all think through adopting policy changes. So essentially this conversation and these 3 slides are really just a jumping off point to begin to customize policy options specifically for Vermont in the fall. None of these right now are customized for Vermont as you see them. They're really just broad ideas that we want to discuss with you and kind of get feedback on. So first we have the two main policy ideas that Sarah B. just covered. The first is that we know that creating system-wide sentencing guidelines improves consistency in how penalties are applied across cases and offense types. So establishing a sentencing structure to increase uniformity and proportionality in sentences. And then also kind of maybe a step below that would be revising statutory language that allow for differences in sentences across similar cases. So for context on that, there's about 20 states in the federal system have sentencing guidelines that their judges use when they're considering sentences. And these can look different, but in the most structured sense, they're very kind of presumptive grids, kind of at the one spectrum of structured sentencing. And then there's other kind of incremental ways underneath that. That is not where Vermont is right now, as I think pretty much everyone here must know that Vermont currently is on the other end of the spectrum. If a very extensive kind of intricate grid is one end of the spectrum of structured sentencing, Vermont right now is on the other end of the spectrum with a very unstructured sentencing system. We know that generally I want to acknowledge that we know that you all have a sentencing commission that has been working to add some structure to Vermont sentencing system. Generally, we know that we do not think that we would suggest moving all the way from one end of the spectrum to another, but we are that there's likely not an appetite in Vermont like that for that. But I think we can still look at places where some structure can be added in a way that's generally shown to reduce disparities, like that probation guidance that you all have on the books, which is not presumptive. It's not mandatory, but has shown to reduce racial disparities in how judges set probation lengths. So the second place, based on the research that Sarah just presented, is reclassifying offenses that are shown to have disparate sentencing outcomes. And this is one way we really hope the results of our analysis can help Vermont, that we can help you pinpoint where there are certain offenses with large disparities, and that might be where you consider looking at reclassifying offenses. And in particular, assuming that Vermont does follow where the national literature has seen, thinking through felony drug possession and drug possession generally, and how that should be classified in order to decrease disparities. I think there are other things that we may also suggest for reclassification, but we're assuming that possession might be one of those places that Vermont would want to target. So unless anyone wants to chime in here, I'll go to the next slide. And there's other ways that we can kind of target these, target disparities in drug offenses specifically. We have this preliminary analysis and we have phase 1 findings that show that there are racial disparities in drug offenses right now for Vermont. So thinking through reducing penalties for those offenses may be a way to reduce disparities. One way that other states have considered this is to look at how thresholds are set, particularly around possession. So in many states with possession, kind of thresholds for possession, at some point when someone is holding enough of a substance, it moves from possession to intent to distribute. Vermont doesn't have that necessarily. You all have just many levels of possession, but thinking through where should those thresholds be? If you increase thresholds, that may reflect an evolving understanding of how substance use disorders work and address a policy area that has historically greatly increased the number of Black people in the criminal justice system and expanded lengths of incarceration. There's also some preliminary encouraging research on the use of alternatives to incarceration for groups that are typically over-incarcerated related to drug offenses, and structuring that in a way that can reduce disparities in particular. And then also, thinking through how are maximum sentence lengths used to ensure consistency, and is that a place where there might be disparities also happening. Okay. All right, next slide. Oh, there we go. So then the CSG team has also been brainstorming and talking to some folks in this room about things that we hear as narratives in Vermont around why disparities might exist. So I'm actually going to take this slide backwards. I'm going to start with plea bargaining, but you all remember, I know that many people remember and many people bring this up to us and in meetings but 99% of Vermont sentences are actually determined through the plea bargaining process. And so if we're thinking through that and we're thinking through sentence lengths and how sentencing happen, and if there are disparities in sentencing, well, how do we look into the plea bargaining process and what might be contributing there to racial disparities? And I think this is this is a place where you could do a lot of different digging, and there's a lot of emerging ideas around plea bargaining right now nationally. So one important place is just that right now plea bargaining is a real black box. We don't know what's happening in Vermont and plea bargaining systems, which is actually very typical nationally. These are kind of decisions that are not recorded. There's not data collection happening around plea bargaining. And so trying to open that up and kind of shed transparency on the plea bargaining process so that it can be studied in the future, so that Vermonters understand what's happening would be a really kind of standard place to start in thinking through racial disparities at plea bargaining. There's also the idea that there could be some sort of oversight role for judges or for others with plea deals to kind of flag if deals are coming in that are not equitable or that are kind of that are not consistent across different defendants. Additionally, we've heard talking to other Vermonters, we know that there's been there could be prosecutorial plea bargaining guidelines, not on this slide, but something that came up very recently for us around how plea bargains are made and how charging happens as well. And there could be a role for training with judges and prosecutors around plea bargains and increasing equity in the process. So the last two, not on this slide, but other ideas that have come up recently as we've continued to kind of work through how the plea bargaining process might contribute this, and what are some ideas to both pinpoint it and create change. And then lastly, we know that we hear a lot, and there's been conversations in this group in particular and among others about how criminal history might contribute to sentencing decisions and racial disparity within sentencing decisions. And we're definitely digging in on that. We're going to have a lot more information to share with you all in the fall about, statistically how criminal history may contribute to this or be controlled for in looking at different racial disparities. And Sarah B can definitely dig in much better to that than I can as our research manager. But if we're worried about criminal histories and the use of criminal histories really biasing the system, especially when certain communities we know are over-policed and have compounding unequal treatment as they move through the criminal justice system, leading to longer criminal histories, then how can Vermont think through how criminal histories are used at sentencing? So creating a process to identify and reduce bias in how those past convictions are considered, and perhaps within that, thinking through guidance to calibrate the weight of past convictions in sentencing decisions, particularly making sure that criminal histories that are considered at sentencing are reviewed for the recency, relevancy, and severity. And so basically making sure that they're related to the current offense that's being sentenced at the time. So I wonder, those are the big policy ideas we're essentially throwing against the wall for you all. And we have some discussion questions on the next slide, but before I kind of go into those specifically, I do wonder if anyone just has any thoughts as you're hearing me. Very interested in thinking. We have heard from people like, hey, this will not work for Vermont at all. This doesn't resonate with us. Yes, I think that there's pieces of this that could help. Or we also know that we have, I believe Judge Zone is on the call right now. We know the Sentencing Commission is working on some of these or some interrelated things to this. So very curious to hear from you all what resonated or what really didn't resonate in those 5 policy options.
Sarah, can I ask a question?
Yeah, of course.
Yeah. Can you said that we are at one end of the spectrum on this. Can you identify any other states that are similarly situated, or are there none?
I have to admit, not off the top of my head, but there definitely are. So about 20 states right now have guidelines, which means 30 states do not have guidelines. But I think one thing that makes Vermont particularly unstructured, which is not as common in other states, is you also don't have any sort of classification under your felony and misdemeanor levels. So I'm sure many people are aware, many states have severity of felony misdemeanors, or of felonies and misdemeanors, class A, class B, class C offenses based on the severity. And Vermont doesn't have that either. I know that there's been talks in the state about could you add that, how would that work, etc. So not only do you not have guidelines, which you're in good company with, you're less than half of states do have guidelines, but you also don't have that underlying sentencing structure, which is definitely less common across states.
Can I chime in, please?
Yep, please.
Yeah.
Okay, great. So to answer your question, what resonated, I first want to say I really appreciate this discussion and your analysis. And so some of the things that that we're doing or have done or I'd like to continue to look into would be our criminal code revision that that we have started. I think the reclassification of drug offenses is something I know that my committee would certainly be very interested in. We have looked at that and done some of that, as well as looking at felonies and perhaps changing, certain drug offenses to misdemeanors and looking at possession, which again we also have done. Plea bargaining also I think is a great place to be looking at, and criminal history, the use of criminal history is something that my committee and also the Senate has been looking at over the years, and as well as expungement, which is certainly a priority of mine. So this is very, very relevant to me. So thank you, I appreciate it.
How do, if I could ask another question, how do charging decisions factor into this in your review of the data in Vermont? Have you got any comment about that, Sarah?
So I believe that, and I'll have Sarah be confirmed, that I don't think that we have data on charging specifically for our analysis. But looking into, because what we'll be using for our analysis is courts data, which doesn't, I believe, have initial charges. You can't see how charges change. You just see the charges that were convicted for. VCIC data for the criminal history, and then also some DOC data. But we have been looking a lot into the plea bargaining literature around plea bargaining, just to be prepared and to kind of flesh out that policy idea. And I think there is research about how charging really can impact plea bargaining and how charging has shifted historically as kind of incarceration rates have risen within the plea bargaining process. So
What does it say? Can you give us some idea what the literature says?
Yeah. Yeah, that I'm sorry, you all can hear me even though the drilling has started? Okay. So you can hear me, I may not be able to hear my own thoughts. Yeah, I think that there's really a case that if you're looking at guidelines for prosecutors and adding more structure to the plea bargaining process, that it can't only it doesn't start with the actual plea bargain. It could start and should start with looking at how charges are brought in the first place, and that it definitely and also that over the years, as incarceration has risen, the number of charges being brought against people have risen. Like have risen, so that there's been actually a shrinking number of people in the criminal justice system, but but more cases and more charges brought against each individual.
I'm not surprised to hear that.
Sarah, could I just clarify something quickly?
Oh yes, please.
Okay, just to speak to Justice Schreiber's question. So to answer your question, we don't have data that gives us a lot of insight or detail into the plea bargaining process, right? That's a black box in Vermont and frankly across the US it typically is. We do, just to clarify, we do have information on filed charges versus charges of conviction, and I am looking at that as part of the analysis. So we will be able to show you, for example, what sentences look like relative to the most severe initial charge in a case. And I'm not sure if that's answering kind of the, the thoughts underlying your question.
Yeah, I think that would be helpful, Sarah. Is that at the next meeting, you think, or when?
So we're scheduled, and this is a different discussion point that I know our team was going to bring up today. We're scheduled to present those in November, and I know we'll talk about that, the logistics of that in a little bit. And the reason for that is that we are actually still waiting on the last piece of data for this analysis. So we want to make sure our timelines are aligned with when that data comes in.
Yeah, okay. Thank you. Yes.
Just, if I could, a couple of questions are raised here. And I agree with Representative Grad that it would be helpful to kind of focus on one or two solutions here, rather than all of them at once. And so maybe for the November meeting, if you could give us an idea of what might be effective and what might make a change. For example, would the reclassification of drug crimes help? Would plea bargains, more transparency? What has been most effective? The second question, we know that in Vermont, we have huge geographic disparities in terms of sentencing and in terms of charging individuals. And I don't know if that's taken into account in any of these studies. And finally, is there any difference in the sentencing of out-of-state people who came here from other states and were convicted of a drug crime, for example, versus Vermonters, both on a racial basis as well as other basis? Was there any disparities there? A lot of what people tell me is, well, you've got more persons of color incarcerated, but many of them came from out of state. Is there any evidence of that in your study?
Sarah, do you want me to take the data focused questions, and then I don't know if you want to speak to the policy item?
Yes, I'm pitching all data focused questions to you now, Sarah, since I definitely got the nuances wrong on that last one.
No problem. So Senator Sears, just to speak to your data focused questions. So there's the one about geographic disparities and then in-state versus out-of-state. We are able to look at geographic differences in the analysis, but I think we mentioned this briefly in June when I kind of outlined our research plan. We're not, I'm not able to look at racial disparities and how they differ across different courts in Vermont. And the reason for that is that it's a statistical limitation. So as you start to cut up the data into smaller and smaller pieces, you lose the ability to make these contrasts between racial groups. So the main racial disparity analysis is going to be across the state, but I can definitely look at geographic differences for you without that additional racial disparity component. So we'll do as much as we can with what we have. In terms of in-state versus out-of-state, we do have information on that, and I am absolutely planning for that to be part of the analysis that we present to you, because we've certainly heard that that's an important question to Vermonters. I do think, though, that the phase 1 analysis, if you remember that snapshot slide that we went over just a little while ago that shows the sentenced incarcerated population, what that phase 1 analysis showed is that racial disparities between Black folks and the general sentenced population are pronounced for Black people who are Vermont residents, as well as people who are not residents. So we do already know, from those initial analyses that this appears to be an issue that is sort of independent of, state of residence. But we'll look into it in more detail for what we present this fall. And then I can maybe pass it back to Sarah Friedman to handle.
Thank you very much. That's very helpful.
Yeah. And I think the other part of that question, and correct me if I'm not responding to the right thing, was just about focusing on solutions for the November meeting that are most likely to be effective and make change, and kind of the supporting evidence on what is effective, and that's 100% what we're planning on doing. Yeah. And although I will note, and part of this conversation is that national literature and what states have done really focus on a few key areas like guidelines and reclassification, and but that doesn't mean that there aren't other places that we really think that Vermont could impact this based on our conversations and our kind of Vermont specific knowledge, even if there isn't, a huge long basis of research literature to back it up. We do want to continue to explore those areas, and you will see other policy options from us that we think really will make sense for Vermont, even if other states have not even if there's not, a whole class of other states that have implemented them, because we think it's really important to acknowledge that we know that there are policy levers in the system that can impact racial disparities, even if they haven't been kind of fully studied yet. And we want to make sure we're presenting those to you all as well. So I noticed that Karen Scott, you've had your hand raised for a while. If you want to chime in.
Thank you so much, Sarah. I want to go back to the recommendations around drug reclassifications and just point out that those recommendations would be really important for incarcerated women or women who are charged with drug crimes, especially when they're sitting in the right in that nexus of trauma, of substance use disorder, and especially for women who are involved in human trafficking. So happy to see that those recommendations are being made. Thank you.
I realize I'm not quite sure how we're doing on time. Let me just check my notes quickly before I throw out another question. But let's see. I think I need Loretta's timekeeping to keep me on track. But I do wonder specifically around the last two policy. Are you trying to mute when drilling comes on? Around criminal histories and plea bargains. Those are something that we've been thinking through specifically related to conversations we've been having with folks in Vermont and have heard historically throughout this process. And you all remember that the CSU team has been kicking around Vermont, mostly virtually, since summer of 2018. And so these are just kind of themes that we hear come up within our work. And if there are current initiatives going on around kind of rethinking criminal history or addressing plea bargains, or if folks on this phone as experts have thoughts on that. That's kind of, those are, I guess, more preliminary policy options that we'd love to hear from you all about. Okay, well, maybe we're not ready yet, but just so you know, you will be hearing from CSCT members who are reaching out to talk to all of you after this meeting and think these through, perhaps not in the group setting. And we, of course, want to make sure that all of the right people kind of have their voices heard in this. Some other policy ideas that we've been kicking around also might be of interest to folks, and curious if anyone has feedback on them. So one thing that we know is going on in some capacity around in Vermont is discussions around racial impact statements. So thinking through as new laws are being passed that that impact criminal penalties, and that those would be accompanied with kind of impact statements or some sort of accounting on their potential impact on racial disparities, you know, to make sure that there aren't policies going through that that exacerbate disparities. I think that you'll also hear from us, no surprise here, that we'll be making recommendations around data collection and improving that probably at multiple points within the system. We've already made some. We know that there's a lot of folks, you know, particularly Dr. Nesrattam Longo and RDAP, who are also working on this. But that's something that we're definitely thinking through as a component of this, although that won't be kind of the only component. We're looking for more looking to propose more structural changes as well. Also, some states have been effective at having sentence review boards. So, so an opportunity for people to appeal sentences if they think that they are disproportionate or not aligned structurally or outside the bounds of a normal sentence structure. And then I mentioned this before, but you know, we've heard from some people in Vermont about needs for additional training. And what that might look like to help judges, prosecutors, and I would perhaps maybe add in there defense attorneys think through how they can reduce disparities within their day-to-day work.
This is a midsummer meeting, Sarah.
People aren't ready for this. I know, and I also know a lot of folks are on vacation today, so
yeah.
I know these are really weighty issues. We've talked to some of you prior to this meeting, kind of preparing for this. We're going to be reaching out to pretty much everyone after this meeting as well, or to folks, if folks have thoughts that they want to come to us with as we kind of vet and think through these things and make sure that we're proposing policies that make sense for Vermont in order to, and pinpointing, using the analysis to pinpoint those areas where we think you have the greatest impact. So you'll be hearing from us probably very shortly to keep drilling down here. So, which means with that, if no one wants to volunteer or, oh, yeah.
Sarah, Susanna has her hand up.
Oh, I can't see that. Susanna, please chime in.
Thank you. Yes, I just wanted to say that I appreciate all of these recommendations because racial disparity is bad. And in particular, I mean, discretion it can be deadly, but it can also be effective. And being able to implement solid policy changes that allow us to intervene where we see disparate or unnecessarily harmful outcomes happening is important. And more important than that is the really structural ones that are designed to make it so that we don't need to intervene with those discretion points in the first place. Those are going to be really key. So, for example, the equity impact statements that you mentioned, that's something that we do in the executive agencies for all budget and policy asks, to do an equity impact statement to accompany it. And I understand that there are some members of the legislature who've been putting together something similar for that branch. It's something that I think we should be using across state government. So that's one that I think is particularly effective. And but I appreciate all of those recommendations, and personally think that we should. I know that we should bite as much as we can chew, but I am enthusiastically recommending that we take on as many of them as we can at one time, because it's a big deal. Thank you.
Thanks so much, Susanna. I really appreciate that. And I think you're a little blurry for me at the beginning, but I believe you had a point about discretion. And I do want to note that I think we do have, we do have literature that really points that the combination of discretion with some sort of structured guidance is really where you get the best outcome. You don't want to take discretion away. Discretion is really important, and you're not going to hear recommendations from us that completely pull discretion out of the system. There's a lot of really good literature on this around actually risk needs assessment and things like that, and kind of emerging literature at sentencing too, that you need the combo. You need the folks, you need room to move within the system, but you also need some guidance so that you're increasing uniformity, especially when you're thinking through disparities. So that's definitely something the CSG team is thinking through. Is what is the balance, and how do we kind of increase that balance in Vermont so that folks are not working within a totally unstructured system, which we know not only creates racial disparities, but we hear a lot in Vermont about the geographic disparities as well. And I think that when I'm reading this literature, I always think back to that too. It's like, if you can build some sort of framework and some sort of guidance that doesn't take away discretion, but helps people have better informed decision making, I think that we could have a big impact here.
Sarah, this is Pat Gable. I was wondering if you could maybe give a more concrete example of what the combination of guidance but discretion looks like, either by way of a specific example, or maybe you want to refer us to a particular system already in practice that's shown good outcomes.
Yeah, I think that one way to combine discretion and guidance is, I mean, although Sarah B did present that, I would say that there is research that shows that presumptive guidelines are most effective. I think that it really depends on how you implement things generally. So a combination of having guidance on the books that is not mandatory, and so still leaves room for discretion within the judges, but gives people kind of the bounds of where things should be and how they should consider things. So that could be within sentencing structure, so how sentences should be placed, but I'm also thinking a lot about how criminal history is considered, and that if there's some more guidance on the books on how decision makers take into account long rap sheets and how they factor that into their decision making, and training on that, guidance and training on that, that would not take away total discretion, but would just give people more understanding of context for how they make their decisions, and how those decisions can, I see 8 tons showing me that the drilling is going on. or I'm sorry, I'm sorry, you all. Unfortunately, out of my control. But more, and I've lost my train of thought. But essentially, additional guidance of how to use that discretion, essentially, and how those decisions have impact throughout the system.
So it sounds like maybe three factors. One is a certain presumptions. Two is education and training about how to evaluate those presumptions. And is three something like if a judge were to depart from the presumptions, there'd be findings on the record as to why, something along those lines?
Yes, that's definitely the most common way that is handled.
Thank you.
If I could jump in real quick on this point, David Chair with the Attorney General's office. One example we have of something along the lines of what you're talking about here in Vermont already was I believe it was the 2017 change to presumptive referrals to diversion for a certain category of lower level misdemeanors. And essentially, it still leaves complete discretion in the hands of the prosecutors as a technical matter. But in order to override the presumption, prosecutors were required to state on the record in court why they were not going to follow the presumption. And after that happened, we saw dramatic increases in the use of diversion. Like it doubled statewide and increased dramatically in every county. So that was an example of where we retained discretion technically, but put on the strong presumption that put the onus on prosecutors to have to put on the record why they weren't going to follow it. And it had a really dramatic effect in reality. And so I think that was an example of where that worked quite well in Vermont. And just speaking generally, our office would certainly be very supportive of working towards this end that's been put in the report in terms of whatever this ends up looking like, standardizing outcomes in a way that hopefully reduces disparities, whether that's lowering maximums, putting in presumptive guidelines, things like that. We think this is a worthy goal and we're happy to work to achieve this.
Thanks so much, David. Really appreciate it. Eitan, I see that your hand's up.
I certainly know that when I drive around and I get cut off by someone from New Jersey or Massachusetts or something, the words that come out of my mouth are not printable. Is there real evidence here to support that the crime X committed by a Vermonter, a Black Vermonter, crime X committed by a Black non-Vermonter results in different sentences?
I will pitch that one to Sarah Bostomsky.
And just to clarify, is your question whether the evidence we presented is speaking to that, or are you asking, is that something that we can look at for the fall presentation?
I'm going to say something strange. Yes.
Yes to both. Is that what you're wondering? Okay. So to speak to the phase 1 analysis slide that we showed earlier today, that analysis showed that Black Vermonters and non-residents of Vermont as well, who are Black, are more likely to be incarcerated for a drug offense. In terms of more specific offense type within that category, that information is not there. And the problem, I think, is that the number of people who are incarcerated for that offense class is already relatively small. So you kind of lose the ability to make those finer level comparisons for the phase 1 analysis that was done.
Is this something that... No, I just Is this something that would be better examined using a qualitative approach?
That's a great question. So in terms of the work that we're currently doing that will present this fall.
Sarah, sorry, we're getting an echo. Oh, and now I have it. Eitan, I wonder if you muted yourself in between, if that might stop the echo. Okay, thanks. Let's try that. That might be more helpful, Sarah.
Okay, thanks for catching that. In terms of the analysis we'll present this fall, it is strictly quantitative. It's a statistical analysis. And the goal is that we want to be able to share results that are representative across the state, that speak to the system as a whole. Certainly qualitative analysis is valuable, but I think in this particular case, that might be something to think about longer term. To get back to your question though, one thing that we can look at for the results that I'll present in the fall is sort of some of the specific offense classes. You know, within felony drug offenses, we can look to see, are there differences for drug possession versus trafficking? So we will be able to drill into some of those differences, and we've been thinking a lot about that. So I think you're getting at a question that our team is really interested in and currently, you know, in discussion about.
So that's come up in multiple venues, that out-of-state folks and the drug offenses. And you know, Karen also put it in the chat, and we've heard it. We hear it like very, very often in our meetings. And so we're going to do what we can to get to that. But we're not sure we have, you know, the kind of statistical power, enough numbers to do it. But we'll give you as much as we can on that, as that's as a narrative that comes up pretty much in every meeting we're in, and folks really wanting to know if it's true. But so that's a goal, but I think that there are definitely some data limitations when it comes to it. So I don't see any other hands up right now. I know sometimes we miss them. Okay, great. Well, Susanna, thank you so much for chiming in a way that spurred additional conversation. Really, really appreciate this last part of the discussion. And with that, I will, unless anyone has any late-breaking comments, I'm going to pass it back to Madeline, who's going to initiate the parole for older adults conversation, which is one of the JR2 working group's statutory duties.
Thank you, Sarah. And I'm going to share my screen again, folks. All right. And so as we go through this section, I'm going to be a little bit cognizant just of our time and making sure that we end with enough time for you all to have some discussion, and then also for us to do some wrap up and planning for the next meeting. But please feel free to stop me if there's something that I go through too fast, or that if you have any questions or want me to slow down anywhere. So for this next section, we're really going to just, begin and initiate the conversation about a parole for older adults policy in Vermont. We know this is something that's been kicking around the state for the past several years. And what we're really hoping to do today is really share some Vermont specific information, some national state examples, as well as walk you through a limited data analysis that we were able to do to hopefully inform a discussion at the end of the presentation that can help us develop some policy options for you to consider at the October meeting. So this is really just kind of a foundational informational session in preparation for looking at some more specific policy options that can be tailored to Vermont, should that be the direction that you all decide to go. And so, as you all know, Act 148 does task you all with evaluating a policy for allowing parole eligibility for older adults who have served a portion of their minimum term. So just to clarify, that's folks who have not served their minimum, and so they are not eligible for the traditional parole process. And we want to be really specific on our language here, because I know you've heard us use the term compassionate release. We know you all have used that term. And we just want to be clear that that refers to both medical parole as well as parole based on age. And so medical parole being parole based on a person's medical condition. And then geriatric parole, or we're going to use the phrase parole for older adults, would be based on a person's age or age-related illness or infirmity. And so during this presentation, we're going to be really specific about those two types of parole. And then when we say compassionate release, we're really referring to both. So hopefully that's not going to be too confusing. And one of the reasons that we want to be particularly specific is that Vermont does currently allow for both medical parole and medical furlough. And you'll see right here just the steps in the some components of the policies for both medical parole and medical furlough, and you'll see that they're very similar. So in both cases, a person must be diagnosed with a terminal or serious medical condition. Both allow for release to a hospital, a hospice, licensed inpatient facility, or another suitable housing accommodation. They both require that the Department of Corrections do a review and make a recommendation on a particular individual based on a range of factors in the policy. And these include offense, time served, the risk level of the person, any victim concerns, age, and then the suitability of the release plan. And then you'll see at the bottom, here's where the two policies diverge. So for medical parole, obviously it's the parole board that makes that final release determination. And for medical furlough, that's going to be the Department of Corrections. And so when states do look to have a parole for older adults policy, a lot of times their policy goals are very similar to the goals for medical parole, but they have a more explicit focus on the aging population. And so you'll see some of those policy goals here, probably nothing too surprising. So reducing correctional healthcare costs related with treating older adults who can be, which their care can be significantly more expensive than your average incarcerated person. Reducing the rising number of incarcerated older adults in the prison population. This is a national trend, and we'll talk a little bit more specifically about what this looks like in Vermont a little bit later. Increasing access to a higher level of day-to-day care than what a person may be, what may be available for a person in an institution. And then there are several states that have actually, as they either in statute or in kind of legislative history, as they talk about why they're putting a particular age-related parole policy on the books, have expressed they want to provide a humane alternative to continued incarceration for people who are suffering from age-related issues. And so we bring this up because it is really important as you're thinking about putting any policy on the books for you all to think about, what the goal is that you're trying to accomplish and how you want to make sure that you're tailoring your policy development as well as your implementation to actually, achieve that goal. And so as you all know, there have been several efforts in Vermont to pass a parole for older adults policy that have not been enacted. So that's starting in 2013. There was a policy that had eligibility, which included people 55 to 65 who have who served at least 10 years. And then for people who are 65 or older, they have to have served at least 5 years. In 2019, S167 actually proposed a little bit of a different process, that a judicial process where people would go to the courts, people who are 65 or older, who suffer from a chronic or serious medical condition, or are experiencing deteriorating health, for a adjustment in sentence for release. And so, this is an option that was recently created at the federal level, but we actually haven't seen any states that have implemented a similar judicial process in some of our research. And then finally, in 2020 and 2021, there were 2 efforts to look at a policy that included eligibility for people 65 or older who have served at least 5 years, fulfilled their programming requirements, and who have not received a major disciplinary rule violation within the past year. And so when you take a step back and you look at nationally, you'll see that some type of compassionate release policy, whether that be medical parole or parole for older adults, is fairly common across the US. So these states in orange have just a medical parole policy. The states in blue have a medical parole and a parole for older adults policy. And then you'll see just one state, Virginia, that only has a parole for older adults policy. And there are only 4 states that don't provide for some type of compassionate release. And so when we drill down a little bit further to look at what the eligibility requirements are nationally in state statutes, we found that most states limit eligibility to people 60 or older, do not require a person to have served any set duration of their sentence. And so what you'll see here is just a kind of a survey of what we found as far as eligibility requirements in states. And then I also want to make sure that I point you all to a handout that came with your media materials that's basically a national policy scan that gives you details and statutory language on each state that has a parole for older adults policy. So you'll have that as reference, but on the next couple of slides, what we're going to be doing is just pulling out some highlights for you all. And so what we found is 7 states require that a person be at least 60, and 3 kind of raise that age level and require someone to be at least 65. There are, interestingly, 4 states that do not have an age requirement. And what they do is they base their eligibility on the physical incapacitation or reduced risk to public safety due to age of that person, but there is no actual age bar. So it's kind of an interesting hybrid between a medical parole policy and a parole for older adults policy. And then 8 states do not require that a person have served any set duration of their sentence. So they don't have that 5 years or more, 10 years or more that you see in other policies. And then there are 2 states that propose something similar to what was considered in Vermont previously, where there's 2 tiers. So for someone who's 60 or older, they have to have served at least 10 years. They're 65 or older, they have to serve at least 15. And so in addition to age, some states also require that a person also have some type of qualifying age-related infirmary or illness. So this is, again, a little bit of that hybrid medical parole, parole for older adults policy, where there has to be, so a person has to have met a particular age eligibility, 60, 65, and in addition to that, to qualify for review, they also have to be diagnosed with some type of age-related limitation, infirmity or illness. And we share some examples here. So in Missouri, you'll see that an incarcerated person must be incapacitated by age to the extent that they require long-term nursing home care. In North Carolina, a person must also suffer from chronic infirmary, illness, or disease related to aging. And then in Oregon, they don't have, they're one of the states that don't have an age limitation or age bar, but an incarcerated person must also be permanently incapacitated. And so we did want to pull out a couple of other components of state policies for you all to consider as you're thinking about a parole for older adults policy in Vermont. And those additional components include offense carve-outs. It's fairly common for states to have offense carve-outs for a range of violent and or sexual offenses. There's also requirements that a person serve a defined portion of their minimum sentence, so not just a defined period of time, but actually a portion of their minimum sentence prior to parole consideration. Most states have some type of victim notification or policy, or also thinking about when a victim is should be identified or should be for when someone is identified or approved for parole release, when that information is shared with the victim, and making sure that there's an opportunity also for victim input prior to decision making. And that happens at different points depending on the state policies, but it's generally a key component of a state parole for older adults policy. And then just as Vermont was considering excluding folks who are serving life without parole, that's also another fairly common policy component across the state. And some states also actually put additional criteria for release in statute, so not just in policy, but in the statute itself, including reduced risk, that person be reduced risk to public safety or risk to recidivate. And as we mentioned before, nearly all states, the final release decision is actually going to be made by either the paroling authority or the corrections department. And so we were able to do a limited data analysis to try to inform this conversation about a parole for adults policy by being able to access some of our phase 1 information, our phase 1 data. We also were able to pull information from Department of Corrections public file, and then they were gracious enough to be able to provide some additional data to help us be able to basically do a limited population profile, so that you could see if a policy was enacted under some specific criteria that I'll talk about in just a minute, who might be eligible within your current incarcerated population. And so the criteria that we decided to use based on criteria that you all have considered in the past, as well as what we see as being kind of standard nationally, is listed here. And that is that a person be at least 60 years of age or older, that they've served at least 5 years, and that they've not yet served their minimum sentence. So again, they're not eligible for release through the standard parole process. And before we go into the data, I just want to make a quick note that due to some of the analysis limitations that we have, we weren't as accurately able to account for readmissions over time when we calculated time served. That we would like you to consider this as a strong estimate, although we have in our conversations with Department of Corrections and the Parole Board as we're reviewing this data, have gotten some assurances that this is very much in the ballpark of what they see from their experience. And so before we dive into deeply into just that 60 plus 5 years or more population by that eligibility criteria, we want to take a little bit of a step back and just look at Vermont's aging population over time. And so what you'll see in this chart here is Vermont's sentenced incarcerated population from 2015 to 2021. And you'll see in that blue bar, that's the percentage of the prison population that's 55 plus. And then in the orange, you'll see those are the folks under the age of 55. And so what we see here is that there has been over these 6 years, you have seen about a 10% increase since 2015 in that population of 55 or older. And that's kind of despite actually that reduction that you see due to COVID that we talked about previously in the sentenced incarcerated population. So even when that population, the total population was reduced, that population of ages 55 and older remained fairly constant. And this is not uncommon. This is something that states are seeing nationally, is that this percentage of folks in the aging prison population have been increasing over the last several years. And so then when we look at those folks who are 55 years of age or older and Vermont's sentenced incarcerated population, what we found is that over half of those folks are 60 or older. So you'll see about 47% are between 55 and 59, 27% are between 60 and 64, and then 26% are 65 or older. And then probably not surprising, if you look at the demographics for the 60 plus population, the vast majority are white and the vast majority are male. And so then if we drill down a little bit further and we're thinking again about this population of folks who are 60 or older that have served 5 years or more, you'll see that this particular chart shows the portion of the minimum sentence served for the Vermont population who are 60 or older. And so within that orange circle, those are the 18 folks that have served at least 5 years of their minimum, of their sentence, but not yet their minimum. And so you'll see that 34 people have already, who are 60 and older, have already served up, at least to their minimum release date. And then you'll see that there are 30 that have served less than 5 years, but not yet their minimum sentence. 12 who have served between 5 to 10 years, but not their minimum sentence. And then about 6 that have served more than 10 years, but not their minimum sentence. So that's where we get so when we're really talking about the population that could be eligible underneath the criteria we discussed earlier of 60 or older, having served 5 more years or more, we're really talking about those 18 people that are in that orange circle. And then we also did look as well at the duration of their sentence that these folks have served. And what we found is that of these 18 people, 9 have served over half of their minimum sentence. And so then the next step in our analysis was to really look at these 18 people and try to understand the offenses that they are currently incarcerated for. And what you'll see is that we did find that about 77% of these people have within our eligible population are incarcerated for sexual assault or murder. The pie chart on the right, you'll see there's 10 folks that are currently serving sentences for sexual assault and 4 that are serving sentences for murder. This is not unlike the 60 plus population that you see in the chart on the left, where again, about 75% are serving sentences for these 2 very serious offenses. And so we were able to obtain information on the results of these 18 folks of their most recent risk assessment scores from the Department of Corrections. And you don't see it broken down here, partly because we were worried about dealing with such small numbers that we could potentially be getting into some private identifiable information. But what we did see by looking at both the sex offender risk assessment scores and the ORAS risk assessment scores for these folks is that they do tend to be, they were as generally assessed as higher risk. There were only about a couple of people that were assessed to be low risk within this particular data set. This was a little bit surprising given that what we know, what research has shown is that there is a really strong inverse correlation, as you'll see here, between age and risk. So as a person gets older, they are less likely to recidivate. I do want to make a really important note that this is also dependent on recency of the offense and offense type. There is some variability there. And specifically, you'll see at the bottom of this slide, people convicted of recent sexual offenses involving children do not show the same reduced risk to reoffend just because they're older. That being said, there are for many, more offenses, there is that inverse correlation with age and risk, which is why when folks generally talk about the compassionate release population, they're talking about folks who are lower risk to commit crimes and could then potentially be released safely into the community. And so it was really interesting. Our team had a lot of conversations about this because what you see in other states that have similar conversations about either parole for older adults policies is that they're looking at larger populations who are generally lower in risk, who may be serving longer sentences for lower level offenses. And that's not what we found in Vermont, as you can see here. That being said, I do want to be, fair. I do want to be really clear that that doesn't mean that there aren't people who are incarcerated currently, or who are potentially be incarcerated in Vermont in the future that would not be appropriate to be considered on a case-by-case basis for this type of policy. And so part of the reason, I'll go to the next slide, that I'm kind of stressing this is that these are generally policies that are applied on a case-by-case basis. So eligibility doesn't guarantee release. And I'll kind of bring you back to the slide that we talked about the process for medical parole in Vermont, that there are multiple steps and considerations before someone is eventually released under these policies. And so it's just an important note. One, it's as you're thinking through the data, as you're thinking through that limited population profile that we were able to do to really understand that, these policies in general take into significantly, other factors when they're considering releasing folks. And the result of that, as you'll kind of see here, is that nationally, what we found is there's really only a little more than 1 out of 10 folks who were eligible for some type of compassionate release from 2013 to 2015 were ultimately granted that release. And while we don't have data for Vermont specifically about the use of medical parole or medical furlough, the anecdotal conversations that we've had with the Department of Corrections and the Parole Board indicate that similarly, these policies are used infrequently in the state as well. And part of that, is due to that case-by-case kind of consideration that I was talking about. There are also, we want to highlight, moving on to the next slide, some other challenges just that have led to the underutilization of these policies nationally. And this is, and it reflects a little bit back to our conversation about policy goals. And so making sure that you all are really, understanding what's the goal that you want to achieve with this type of policy, so that as you're going through policy development and implementation, making sure that you are thinking through challenges that could limit your ability to achieve those policy goals. And so we have listed here are some of the challenges that we've seen nationally around this. The first being extensive statutory exclusions, so really restricting that number of people who could be eligible for a case-by-case consideration. The next two have to really just do with process, so having a long, drawn-out, complicated, or unclear identification process that's confusing both for the incarcerated person and their family, as well as staff and people making decisions. But I really want to draw your attention to this last bullet on the slide, because this is something that we've heard from Vermonters is a challenge with medical parole and medical furlough, that even when there is there's a desire to make a release decision, that there may not be post-release housing, healthcare, other services in the community to ensure that folks are getting what they need once they're released. And this really is, this is something, again, not uncommon. It's something that folks struggle with nationally because these are high need populations. And so, really, as you're thinking about, how do we make, if you move forward with a policy like this and we want it to be successful and meet your policy goals, it's really a conversation beyond just DOC and the parole board. It's really other agencies and community partners coming together to come up with, to make sure that there are resources available for folks when they are, when they release into the community, so that that release is feasible. And so we also, should you all move forward with a policy for older adults, it is important to make sure that you're tracking key measures so that you can kind of understand where, where things, if it's things working as intended, are there adjustments that you need to make? And so we suggest some of those measures here, including, understanding who your total eligible population would be by statute. Of that total population, how many people have been identified for review, and how were they identified? Is that process, missing anyone? Of those folks that were reviewed, what was the resulting recommendation? And then how many people were ultimately released? And then at each of these points, if there was a rejection, really understanding, what the reason for that rejection was. And so we have some discussion questions here for you all. But again, I know that this is something that has been kicking around Vermont for a long time. And so you probably already have thoughts. But just to kind of go over some of the prompts that we were thinking, again, just asking, what are the policy goals you all would like to achieve by having something like this on the books? What eligibility requirements would you like to consider? And then thinking about the notification and engagement processes that you want to make sure are put in place to protect the rights of victims. And so with that, I'm going to stop sharing my screen. And I apologize, I think I missed some comments in the comment section. But I would love to entertain any questions or hear your thoughts about that information. Like I said, we are hoping to move toward being able to craft some policy options based on your feedback for you to consider in October. So any comments that you might have that could be useful in that regard would be really helpful to hear, for our team to hear.
Alice Nitka. In looking at it previously, one of the issues certainly was, as you mentioned, where will these folks go in terms of nursing homes or community care homes rejecting them, or family not wanting them to return? I mean, I think the issue of them perhaps being on the street is a real one, unless there really is community involvement that's very committed. So I appreciate you recognizing that, and it's a real problem. And I know people spoke about it previously who were advocates. So that's all.
Thank you, appreciate that.
This is Falco from the ACLU. I just wanted to say I really appreciate you doing this deep dive to help give us some more information so that we can continue to review this policy and consider it. I know we've spoken in support of this policy multiple times in front of many of the committees in the legislature. But I do think this gives us more to consider. And in terms of policy goals, I think this can help us be more flexible and be more focused on individuals, and whether or not those is the right decision to keep some of those individuals incarcerated. And I understand the risk factors that might be in play, especially for people who've committed certain offenses, and know that the parole board would take that into consideration. And I also say this is a tool that would have been helpful as we were going through COVID, especially in the very beginning when we were looking at folks who were at higher risk from infection and possibly death. And thankfully, services provided in the prison have avoided that. But this is a way that could provide flexibility. It does not seem like it's something that's going to be used extensively just due to the numbers of folks that would be eligible. But I do think it would provide flexibility, the ability to reduce some costs, and also to provide appropriate responses to people, weighing both their criminal risk and then also victim responses. So we continue to be supportive of examining this policy going forward.
Sure, go ahead, Karen.
Thank you. I appreciate the discussion about the risk factors involved with folks who've committed sexual offenses and very violent offenses, and the information particularly about folks who've committed sexual offenses against children, and just thinking with a differential eye about how we approach all this, considering those two, the violent offenses and the sexual offenses. And also, I would make a plea for not only victim notification once a policy has been changed, but I think it might be important for, if we're going to make any kind of policy changes, that we actually engage victims in that discussion, or organizations representing victims. Thanks.
Representative Emmons?
Yes, I'd like to pick up a little bit on what Senator Nika mentioned. I know in testimony in my committee about this over the years, that one of the largest stumbling blocks is particularly if someone needs nursing home care and they are convicted of a sex offense. And what happens is a nursing home is really limited in the possibility of taking the person because they could lose Medicaid funding. And that's a big stumbling block that we've heard testimony on. And if if you looked at our data, a good portion of our folks that might qualify are convicted of a sexual offense. So that has been really limiting, even currently, limiting DOC, even under a medical parole or furlough, that they cannot place some of the folks that DOC or the parole board would be willing to place in a nursing home situation, and cannot do it because the provider would lose Medicaid coverage. So that's a big issue, I think, currently.
Thank you. I know I want to be sensitive to time, but I want to make sure that folks have an opportunity to provide any other comments before we move on. Knowing also that this is going to be a pretty significant topic at our next meeting in October.
Just as you prepare for this next series, would it be possible to see if other states have built nursing homes within their correction system, given what Senator Nick and Representative Emmons just talked about in terms of difficulty of placing? Or do they have geriatric units or whatever? As you're looking at this problem, and we're looking at at least a new women's facility, maybe we should be looking at a geriatric facility as well, so that just curious if any other states have done anything.
Sure. For this presentation, we focused really specifically on the parole for older adults policy, but when we revisit in October. We can
Yeah, it's a
absolutely.
great presentation because it really gives us some ideas, but it also tells me that even in states that have it, they're not able to use it like they might because of restrictions on lack of post-release housing, healthcare, or the services in the community, criteria, whatever. And I think, and I agree with what Karen was saying about victim notification and making sure many of these folks are sex offenders, or murderers and so forth, as you point out. So it isn't going to be, necessarily. I was thinking of when Bernie Madoff asked for compassionate release, and that kind of thing. That just people just be, just say, "Oh my God, not him!" And all the damage he did, or Whitey Bulger, that sort of thing.
Sure, and we can look at some of those
Thank
other
you.
options as well to bring to y'all in October.
Thank you.
So I'm going to share my screen one last time as we move into the next section. I'm going to talk really, really briefly about sustainability. And so this is, a little bit of a, so you all obviously heard earlier all of the work that's going on around your Justice Reinvestment 2 initiatives. And we thought it was really important to actually put all of it on a slide so that you can see that you have all of these kind of different interconnected efforts going on, whether that be your Act 148 implementation, your legislative or administrative recommendations from January 2021, and then in addition, your oversight meetings, as well as, you're exploring other policy options. So in Vermont, you all have a lot going on under the umbrella of Justice Reinvestment 2. And so what we wanted to do was jump the gun a little bit from some of the things that we'll talk about in our wrap-up presentation in December to just, hit on a couple of sustainability strategies that you can be thinking through as you have all of these particular gears in motion. And so these strategies are based on our work in other states, folks who have implemented similar, really significant system changes. And really with the idea that it's difficult to not only achieve the outcomes you're looking for, this is hard work, and I don't want to gloss over that. But it's even harder to actually sustain that change to the point that it becomes just how your system operates and how particularly your criminal justice system operates with other systems within your state. And so these are 3 suggestions that we have for you all to be thinking about. The first, and again, wanting to recognize that none of these look really easy on a slide. They are hard, intense work. And so the first being de-siloing your individual efforts. So making sure that all of your individual programs and policies are not only doing what they need to do, but also really connecting together to inform your broader system reform goals. And that this requires really making sure that you're coordinating across projects as much as possible, so that there's synergy there. The second is not surprising, if you all have heard us talk about anything, which is establishing and tracking outcome measures. And again, this is really looking at, your program level outputs. I mean, I almost wouldn't even say outcome, but your program level outputs, and whether or not those are actually leading to those broader system-wide outcome measures that you all would like to see, and reducing reliance on incarcerated resources, making sure that there is information sharing and care coordination across the different systems that engage with folks who are justice involved, and then also making sure that you are that you're thinking about how to better support people with complex needs that are on supervision. And so that requires really being able to think through whether or not, to be able to track those outcome measures and see if you're having the impact that you want to have. And then very lastly, is just coordinating oversight. Justice reinvestment working groups are really unique in that they bring together important stakeholders from across systems and branches of government. And so states have had a lot of success in continuing these groups and using them as a mechanism to really dig into not just justice reinvestment implementation, but also other cross-system policy development and implementation. So having a place where leadership can come from different parts of your system and really talk about your challenges is critical for sustainability of any kind of big system change efforts. And so as I mentioned before, we're going to go through this a little bit deeper in December, but we just wanted to give you a preview since you all really have are doing such good work right now, that you can also, start to percolate on ways to make sure that you're able to sustain that change after the initial implementation period is over. And so with that, I'm actually going to turn it over to back over to Sarah Friedman to talk through some next steps.
Hi, everyone, again. This is the last slide of the presentation, and I think we're going to hopefully wrap up right on time. But we just wanted to talk through what the rest of the year could look like for the working group. You all remember in January of this year, you set 4 meetings for yourself. So we've 2 down, 2 to go. We have scheduled meetings on October 15th and December 14th. So in the October meeting, we're really setting you up to cover the rest of your statutory duties from Act 148, so that our wrap-up presentation in December, as CSG ends our technical assistance to the state of Vermont, on this project at least, there are other CSG projects going on in Vermont, really can be that final deliverable from our team as our active TA ends. So you'll see here kind of what we imagine is going to happen in the October 15th meeting, considering policy options or recommendations on the material that Madeline just covered, Parole for Older Adults, and we may dive in a little more into the racial equity analysis. You also have a statutory duty to consider appropriation recommendations, and then, of course, the continued implementation oversight. So what we're hoping to do, since our TA ends at the end of December, is that what we present in that December meeting will really be kind of the last deliverables you all get from us, and then we would be happy for you all to use those December meeting materials as the Justice Reinvestment 2 Working Group report that's due to the legislature on January 15th, 2022. But I just want to note, because the way timelines and our funding exists, we probably won't be able to make any adjustments to our materials after the working group meeting. So that puts some pressure on October to make sure that everything is kind of really finalized and set and can be reflected in the December PowerPoint. We're also requesting, hopefully you all saw this in an email, and we've had this conversation with some folks directly, but we're going to be requesting a November meeting from you all, and we'd like to talk about scheduling about now if we have some time. As Sarah Basomsky mentioned, we're still waiting for one last piece of data to come in for our racial equity analysis, and we also think that you all have just a lot to tackle in October, and we don't want to make it a marathon meeting of too many topics. So we're suggesting that we have a November meeting focused solely on the racial equity analysis and potential policy options related to that, to really give that topic its due and not kind of cram it in October. We have some it seems like it probably makes the most sense for folks to do it the week before Thanksgiving. We're kind of softly throwing out November 17th and 18th, but we could do it other days that week as well, to think, so that we can really just make sure that everything, we've dotted our I's and kind of crossed our T's of everything related to the racial equity analysis, and that folks are solely focusing on that in one meeting. So some additional things related to this slide. So, I should say, and then December 14th, we would still be on track to kind of conclude any discussions that you all are having, review implementation progress, and really you'll get what the CSG team does at the end of all of our technical assistance, which is a really broad wrap-up presentation that kind of shows all of the work that's been accomplished and has recommendations for how Vermont can move forward after we leave at the end of December. So I just want, and before I move on, I hope to start talking very quickly now, there are 2 more things that we want to flag for you all. So first, As far as we know, with the Delta variant emerging, the federal government travel ban is staying in place. So we had some discussions as to whether CSC would be traveling to the state and we could start doing these meetings in person, at least for CSCers to be in person. It doesn't look like we're going to be able to travel anytime soon. And I know that this is probably shifting on the ground for Vermonters as well, considering what's going on with the pandemic. So that's going to mean that for right now, we're planning on all remote meetings for the rest of the working group. And if that changes and if something starts going well with the pandemic, that's wonderful. We can consider maybe changing, November or December meeting to in person. But for that's not looking likely on our ability to travel based on how our funding works. So flagging that for everyone. And then last but not least, at least for me, you all heard the chief congratulate me in the beginning of this call. For those of you who don't know, and I think many people on this call do know, this is going to be my last working group meeting because I'm actually very pregnant right now and due in a week, in fact, although you all can't tell because you only see my shoulders on these calls. So the reason that, as you have told, I'm kind of shifting roles, and Madeline is stepping up into the lead presenter role as she did in this meeting. You also may be seeing other members of CSC team come in as we finish out the project, and I will be going on maternity leave very shortly. So it's been really wonderful working with you. I'm really excited about the results and everything that's happening for you in the fall, but unfortunately, I will have to hear about it after it happens when I come back from leave. So just letting everyone know that that you won't be seeing my face at the next meeting, but you're in very good hands with the rest of the CSC team. So I realize that we're at time. I talked through the rest of our time. I don't know if folks could stay on and do a little planning for November. If anyone has any responses about what day or if a November meeting works, that would be really appreciated. If not, we can do it via email and send out a doodle poll.
Yeah, the suggestion was either the 17th or 18th, I think, Sarah. November 17 or 18.
That was kind of our starting dates to narrow it down, but if any of those dates are non-starters, we could kind of expand the options available as well.
Okay. Well, it may be hard to get an immediate reaction from everybody. Maybe we'd leave it that folks would weigh in by email on a problem that they might have with either of those dates and take it from there.
Can you remind us?
Yep, we'll send out. Oh, I'm sorry. Was someone speaking? Yep.
Yeah, this is
Susanna.
Susanna. I was just going to ask, would it be the same time as today's meeting?
It could be if that works. We also were wondering if afternoon meetings might be easier for folks in the room. Weren't sure about that.
So
I think we'll do this via doodle and email. Yeah, I think that'll be the easiest thing, and shoot us a communication if that absolutely does not work for anyone, or no November meetings is prohibitive. But most people we've talked to said that it makes sense and folks would make time for this. So we're going to operate under that assumption.
Okay, Sarah. And I see many congratulations coming along your way. And as Maxine Grad says, it's been wonderful working with you, and we look forward to all the good news ahead.
Thanks so much, everyone. It's really been a pleasure to work in Vermont. I really wish I could have met you all in person one day, I'm sure.
You could come live here, that would be all right. You could do that if you want. We're happy to have you.
It's on the list.
All right. All right. Thank you, all CSG. Thanks to everybody who's attended today. We'll look forward to the meeting in October. Don't forget to weigh in on the November dates and time of day as well. Thanks. Stay well.
Thanks, everyone. Thank you, Chief.
Thank you, Sarah.